Hello, welcome back. Welcome back to Empowered Esquire TV. And this evening, we have a guest with us. We have Mr. Zion Lexx. Would you like to say hello to the people?
First and foremost, giving all praise to the Creator, thanking you for your platform, Phyliciadcpearson. It's been amazing to watch you. It's been amazing to sit behind the scenes as your commentary has been unfolding, and I consider this an honor to be on your show.
Thank you so much for your kind words, and you are welcome here. I want to say hello to everyone who is watching. If you're in the building and you want to shout out, just drop a quick hello in the chat. And if for some reason you've stumbled upon this live, but you're not quite sure why we're here, allow me. This is the saga of the state of Florida v. Michael Nowak, also known as Brother Polight, Part 2. So in the part one of this video, a lot of you had so many questions about the law, so many questions about bail, about prosecution, about arrest. And I thought to myself, there are a lot of outstanding questions, and I try to answer them in the comment section, but it just doesn't do. It's not as well as an actual explanation, right? So I realized that with everything that has occurred, we have to do a part two. So Mr. Lexx agreed to be here with me. It's been amazing that he's going to be here because he's going to be able to share some of his observations as well as ask me some legal questions in regards to his observations and the situation at hand, right? So we have a really, really amazing guest in that regard. Now I'm going to hop into the chat and say hello to everyone. Hello, Health Light. Hi, Unforgettable. Hi, Fab 540. Hi, Nappy Yankee. Hi, Man King. Hello, Sheba. Hello, Flawless Beauty. Hello, Triple C TV. And Nappy Yankee says, share and subscribe, and I approve that message. If you've entered this stream, please hit the like button and share this video. So here's the order of business. First, I'm going to clear up some misconceptions that I've seen running rampant. And then Zion Lexx is going to kind of dig in with some of his questions, and then we'll open up the floor for your questions. So if you know that you have a particular question you'd like to ask, I would say make sure you stick around until towards the end of the stream when we open up the floor for questions, all right? So before I dive into bail, which is the first misconception I want to clear up, Zion Lexx, do you have anything you'd like to say?
I'd first like to just formally introduce myself to your following, your subscribers. So my name is Zion Lexx. I'm a published author 5 times over. I've written books that are available on Amazon as well as Barnes and Noble. I'm an outspoken speaker. I do a lot of public speaking. I'm also a museum tour guide here in New York City for the Metropolitan Museum of Art with well over 35 tours under my belt, with a special love, expertise, and interest in biblical studies, African studies with a focus on ancient Egypt and Ethiopia, as well as the language of ancient Kemet or ancient Egypt, as well as the language of the Bible, which is biblical Hebrew.
So as you have heard, definitely an intelligent guest we have today, right? Alrighty, so let's dive into, I prepared a document for you. If you missed the charges that Michael Nowak is facing, what those charges mean, what potential time of imprisonment he could be sentenced to, go back to part one. You will see me log into that same document, but I've just tacked on bail into that same doc, and we are not re-reviewing that today. All righty. All right, so here we go. Let's go into my doc. So let's talk about bail. Now, I am hoping that this is large enough for everyone to see. Let me go ahead and make sure I can see the chat because I'm going to ask everyone who is here to put a Y in the chat for me if the wording is large enough and you can see it and read it. And in the meantime, I'll take a sip of water. So Y in the chat if you can see the wording well. All righty, I see the Y's coming in. Good. So let's talk about bail, everyone. Oh, goodness, I have to take a deep breath here. There have been some conversations about why Michael Nowak was granted bail. There have been people who have been insinuating that he was granted bail because he is innocent and that somehow bail is some sort of indicator of innocence. Now, I am not proclaiming to know the outcome of this case, right? I'm not proclaiming to know whether or not Michael Nowak is actually innocent or guilty. But what I am telling you about the criminal justice system is that bail has nothing to do with innocence or guilt. Now, I am aware that Tasha K has alleged that there was some mix up with the documentation, and that is what led to Michael Nowak getting bail. Is it possible that there was a mix up with the documentation? Yes. However, aside from that, right, separate and apart from that, bail has nothing to do with innocence or guilt. Let's dive into what bail is and what the factors are that a judge considers when he or she decides if someone should be granted bail. Okay, here we go. Bail. Bail is a monetary amount set by the court to secure a pretrial release. Pause. So it's an amount of money that a judge decides will guarantee that a defendant will come back to court pre-trial. Okay. The amount of bail is based upon the weighing of numerous factors. So it's a balancing of a list of different things. Here's the list. Past convictions and other past conduct. So that's the first thing. Failure to appear in court in the past. That's the second thing. Ties to the community, including family. So does this defendant have family members that he cares about that he would not want to flee and leave? Residence. Does this defendant have some sort of home with said family? And employment. Does this defendant have some means of garnering income that were he to flee, he would not have access to that? The nature of the crime the defendant is accused of. So one of the factors is for the judge to consider the type of crime that the defendant is being accused of. Whether the defendant's release poses a danger to the community. So the judge does also consider whether or not releasing this person could harm someone. Whether the defendant poses a flight risk. So whether or not the defendant could, whether or not the defendant has the means to escape in some way. And then financial resources, which financial resources and flight risk go hand in hand, right? Because if a defendant has a large amount of financial resources, then it's more likely that he or she could flee. So let's review these factors one more time. You're looking at a culmination of a bunch of different things that a judge considers when deciding bail. It is not just one thing. And none of these factors on their own is the deciding factor, because why? It is a weighing of all of the factors. So the type of crime is only one factor in this entire list, right? Posing a danger is only one factor in this entire list. So let's say, for example, hypothetically, of course, Michael Nowak does not have past convictions. Let's say, for example, hypothetically, of course, Michael Nowak has never failed to appear in court in the past. You get where I'm going with this? If the judge reviewed all of these factors and decided that none of these factors are really met, besides the fact that this is a heinous accusation, then the judge may have decided, you know what? I actually think bail is appropriate here. We get that? Don't worry, I will take questions. But we have to clear that up, people. We have to understand what bail is. It is essential to understanding the criminal process, okay? It's not innocence or guilt. That is not what bail is, because remember, you're considered innocent until proven guilty. Remember that. So bail is not innocence or guilt, okay? Now, someone in the comments said to me, bail, bond, what is that? Now I will answer the question of what is the difference between bail and bond. So bail is the monetary amount, right? Bond is a method used by indigent defendants to secure the monetary capital required for bail. So let's say hypothetically, Michael Nowak's bail was an amount that he did not monetarily have. He could go to a bail bondsman, right? Hence the term. And he could say, this is my bail. Can you secure that amount? And he has a transaction with the bail bondsman who then provides the amount. So that is the difference between bail and bond. All righty, I'm going to stop sharing. Hop back in the chat, say some more hellos. Hello, Sexy Star. Hello, Max V World Media. Hi, Major Moves. Let's see. I think there are a few people I missed. Hello, let me see your transcript. I think I've got everyone else. Oh, Nondescript, L. Smith, Calvin Brumont, Hannah Ajayi. If I butcher your name, please forgive me. Karen Johnson, and Muhammad Brett Edwards. I think I got everyone in the chat. Hello to you. You could be anywhere, but you are here with me and our esteemed guest for the evening, Mr. Zion Lexx. And we just talked about what bail is and how it is that someone is granted bail, because for some reason, people are saying that bail is innocence or guilt, and it is not. So to our guest, Mr. Lexx, is there anything that you would like to cover about bail? Any questions you have about bail before we move on?
Sorry, I was speaking on mute. I definitely have a question, but I first want to preface it with this statement. I want to please ask your audience to excuse my temperament. I'm overcoming COVID. I had COVID since Tuesday. I'm in the recovery end, so you might hear me quickly hit the mute button so I can cough. So please bear with me. All right, having said that, here's my question. So as you noted and as you stated, when Brother Polight received bail, as it were, everyone in the conscious community pretty much suggested that this meant that either A, the crime in question wasn't a serious allegation, or B, that no one can really put their finger on the pulse of what's actually going on with this case. Having said that, here's the question that I want to ask you. You quantify the difference between bail and bond. Now I want to ask you this. Would a person like Brother Polight, who fancies himself to have so many resources, mainly financial resources, what happens in the case where Brother Polight bails out, as he has, but maybe at some later date, Brother Polight is actually sentenced? All right. My question to you is, we know after a criminal case is over, right, a litigant can pursue a civil case, right? Could Brother Polight claim that he doesn't have money after producing large amounts of bail? After, if he was to be pursued by a litigant in a civil case, could he actually claim to not have money? I say that because there are a lot of sources that I know that are close to him. I just want to let you know that, who have been, made it very clear that his money is tied up among his wives and many other mistresses. So as if anyone was to pursue him legally in terms of a monetary stipend, that they really wouldn't get it. My question to you is, would the bail serve as proof that he has the means to pay if he is pursued in a civil case?
Well, that question depends on what the bail ultimately ends up being, i.e. if the bail conditions change. Because to our knowledge, based upon what we've seen, the bail is $1,000. So that, of course, would not be useful to any civil litigant. But let's say the bail conditions change and the amount goes up to something significantly higher. Yes, it is possible that a civil litigant could say, well, Mr. Nowak is arguing that he doesn't have funds. And we see that when he faced criminal charges, he was able to find bail in this amount and that amount. Now, I will add this. Any person who is taking Michael Nowak to court in a civil case, if they are alleging at the outset that they know that he is not the person who has, the bank accounts and the this and the that, then what they should be looking to do then, hypothetically, is bring the people with the money into the case which means bring his wives into the case as co-defendants. I mean, if you're saying you know from the outset that he doesn't have the money and they do, that's what you would do. Now, for example, to bring us to a general pop culture case that some of you may or may not know about, there's a big time lawyer named Eric Girardi. He's currently facing a bunch of lawsuits from people who allege that he took their settlement money. Well, what he was doing allegedly is giving the money to his wife. So guess what those civil litigants did? They brought the wife in as a co-defendant. They were able to substantiate that he was giving the money to her, bring her in as a co-defendant, and now she is the person having to pay them back. So if in fact someone decides to sue Michael Nowak hypothetically, and they allege that he is not the person with the money, common sense would say, bring in the people who do have the money.
Okay. Second question on the bail. Is it common with a case like this to see such low bail?
You know, bail fluctuates from jurisdiction to jurisdiction, it's not even really state-based in general, because for example, you could see, bail in a certain case in the Bronx and then see totally different bail in Brooklyn. And I'm sure Florida is the same way. Different counties, different districts, bail tends to fluctuate. So you really cannot look at the amount of bail as any indicator. To add to the fact that sometimes judges will consider what the financial capacity of the defendant is. And we have to remember that appearance and finances, actual finances, are not the same. Let's have a real life combo. We're living in the age of flexing, right? So just because you see someone online and they look like they have all this money, it doesn't mean they do. And so it's very possible that perhaps people who you think have all this money, when they get arrested, they're letting the court know that they really don't. And then the court is saying, oh, well, since we know that you're indigent, allegedly, we'll give you a lower bail.
That's an excellent point. Thank you very much for elucidating that point. Absolutely.
No problem. Do you have any further questions before we dive into evidence-based prosecution?
No, I definitely want to follow your lead. So yes, let's go into that next.
No problem. All righty. So I see a question in the chat. Now, there are tons of questions in the chat. I'm not going to be able to answer all of them right now, so I'd ask you to hold them until the end, okay? There is one question that I'm going to answer, just randomly picking one, right? But the rest of them, let's hold them until the end. All right, so Triple C TV says, what if he has the money tucked away somewhere else? So I think what Triple C TV is asking is, what if a defendant tells the court, I don't have money, but in fact, they're hiding money somewhere else? That is actually something that a lot of defendants do. A lot of defendants, to receive lower bail and receive some sort of sympathy from the court, will pretend to be indigent when in fact they're hiding money elsewhere. And truthfully, there's no way to attack that unless you can prove they're hiding money. And there has been instances in the past in where prosecution has been able to prove, hey, he's not indigent. We know for a fact that he just transferred all of these funds to his wife, and we can prove it. It's rare, but sometimes prosecutors can prove that the defendant is pretending to be indigent when they are not. And the court does take misrepresentations and or lies to the court very seriously. It is not a good idea. All right. All right, so hello to everyone that is just joining us. We are revisiting the case of the state of Florida v. Michael Nowak. A lot of you had so many questions that the comment section just wouldn't do. And there were so many misconceptions, so we're here to clear it up. If you are just tuning in, we just discussed bail. We are now going to discuss evidence-based prosecutions. I'm going to actually take a moment. You guys know I cannot stand the clacky clack of the keyboard, but it is what it is. So I'm putting in the chat here, evidence-based prosecution. So we all see how it's spelled and we all know what we're discussing. So what is an evidence-based prosecution? Well, here it is. Many, many years ago, many moons ago, our criminal justice system decided that certain victims are very vulnerable. And because of their vulnerability, they're not likely to cooperate with prosecution, i.e., they're not likely to testify. So the government decided, what can we do to still prosecute these defendants when we have these victims who will not testify? And they developed something which, mind you, it is called different things in different places, but it's usually called evidence-based prosecution. It is very often used in domestic violence cases, and it has started to become something being used in these type of assault cases. So here's what an evidence-based prosecution is. Hypothetically, the victim in this case allegedly decides that she does not want to testify. The prosecutor in this case can say, well, I still think that I have a good case against Michael Nowak, hypothetically. I have alleged DNA, I have alleged hotel surveillance, and I can use the original witness statement from my victim. The prosecutor would then take a step back and look at all of that evidence and say, I'm going to go forward without her. That is an evidence-based prosecution. When the prosecution goes forward with a case, even when the victim does not want to. So there's no victim testimony. It is just evidence being presented. Hence the name, evidence-based prosecution. It is difficult to do. I can tell you as an attorney and a former ADA, they're not easy cases to prosecute, but it can be done, and it has been done. Okay? All righty. So greetings to everyone who's just joining us. I see a lot of people saying hello to our guest. And let me ask you now, Zion Lexx, any questions about evidence-based prosecution?
Yes, since we're speaking about evidence-based prosecution, I'd be remiss to not add that there's a growing number of people who are, I guess, confused or out of the loop as regards the evidence on a more clear or lucid level. For instance, the term DNA, it can refer to or it can infer a number of different things. DNA does not have to be one particular thing. So I just want you, if you can, to just clarify for us the fact that the docket mentions DNA. That is not necessarily proof that it is coming from Brother Polight's semen. DNA can come from many different things, your spit, your blood. So this leads to people saying, well, if his DNA is on the girl and he's dating the mom, maybe he's in close contact with the girl. Some people spit when they talk. There's nowhere in the paperwork that says it's semen. What do you say to that?
So there is the world of possibilities and there is the world of practicality. So is it possible that this DNA is something more common, such as, spit or sweat or something of that nature? Is that possible? Yes, that is possible because, as it has been said, we do not have an actual snippet of documentation which says some sort of, semen or sperm or something like that, right? So technically, it's possible. But from a practical perspective, it would be very challenging for any prosecutor to want to build that kind of case on bodily fluid that would have not been secreted in some sort of inappropriate conduct. So, for example, if it's a bodily fluid that, as Zion Lexx is saying, it could just come out of your mouth when you're speaking, well, that's going to be a more difficult case for you to build, right? So just putting on your prosecutor hat for a moment and using your own sense, your own knowledge, you could say, it's not likely that a prosecutor would choose to prosecute that kind of case. They would want to have bodily fluid which confirms inappropriate contact, and that would be semen or sperm. That's the ideal.
Excellent point. Now, I have one question for you, another for you, and this question revolves around the parallelism or how in some states this term is made synonymous, rape and sexual battery, right? We know in the state of Florida, rape and sexual battery are synonymous. They're one and the same on Florida's legal books. But I'd like for you to just, clarify for us what the differences are, if any, between sexual battery and rape, and why, if at all, some states may use them interchangeably.
So some states may use the term interchangeably because very often they're both used to refer to inappropriate intimate contact, whether it be with lower portions of the body or upper portions of the body, right? So that's why sometimes it's used interchangeably. But usually when making the distinction, battery refers to inappropriate conduct, whether it involves, as I said, the lower portion of the body or the upper portion of the body. And we do know that allegedly in this case, most of the allegation and most of the observation that was made by the mother allegedly has to do with the girl's face, right?
Right.
So that is
Right.
why you hear references to battery as opposed to the R word, because the R word is usually something that involves your nether regions. That's the distinction there.
Thank you so very much for clarifying that, because I was looking into it and I was, just familiarizing myself with the term. And then it dawned on me that it would be a great moment to ask you that question. So thank you very much. You certainly answered it.
Absolutely. Absolutely. So I wanted to make sure we clarified what is bail? What does that mean? Does it have anything to do with innocence or guilt? And could this case possibly progress with a victim, allegedly, who decides that maybe she does not want to go through with having to deal with that? And let me say this, if for some reason you are unaware, and let me tell you, if you're unaware of how these cases work, I actually think that that's a good thing, because it means that you've never had someone go through this. But these type of cases in particular, cases in which, inappropriate intimate conduct is alleged, for the victims, it is especially harrowing. It's very, very difficult. It's very traumatizing. And very often, victims walk away from these cases not because they're lying, not because what they're saying and alleging didn't happen, but because they just psychologically cannot handle having to go through this again. So hence the conversation about evidence-based prosecution, because I know a lot of you wondered what could happen if this young lady does decide, or girl, however you like to refer to her, right, does decide that she just cannot do this. She cannot go through with this. So we're going to open up the floor for questions from Zion Lexx. And after he asks all of his questions, then we will go into the chat and get some of your questions. So, Mr. Lexx?
Yes. So, I've already seen a lot of people ask questions as it pertains to Polight's past dealings in the community as it pertains to scamming. You said something in your initial video with reference to Brother Polight specifically that I found very valuable. You said something to the extent when we were talking about, excuse me for a moment, let me just jog it and get my words correctly so that they can come out clear. But as it pertains to establishing a pattern of behavior, that's what I'm going to ask you. So is it possible that Polight's prior history of scamming could be pulled into court, invited into court by the prosecution to establish a pattern of not necessarily sexual battery, but a pattern of, bad character in some way, in some sense?
Very, very interesting question. So the short answer, yes. But of course, I have to explain that. So here's the long answer. It is more likely that Michael Nowak's past regarding alleged scamming and all those things, it's more likely that that could be brought into this case if he decides to testify. And the reason why I say that is because witness credibility, if you're an OG, you know what I'm about to say, but if you're a newbie, welcome. Witness credibility is always relevant. And a part of witness credibility is the witness's character for either truthfulness or untruthfulness. So that means, is this witness the kind of person that would tell us the truth? Or Is this witness the kind of person that has a track record of being a dishonest person? And when you talk about allegations of scamming, allegations of any type of fraudulent collection of money, allegations of fraudulent business practices, all of that could be considered showing that someone has a character for untruthfulness, showing that they're not a trustworthy person, which comes into play, like I said, if the person decides to be a witness. Now, if he decides not to testify, the prosecution may still try to go for it, because that's the thing about the legal world. It's adversarial. So, like I always say, I'm going to make the argument. I'm going to go for it. And then the judge will tell me if I made it or not. So the prosecution may make the argument of trying to bring all of the alleged scamming in, even if he doesn't testify. But it's more likely that they will be successful if he does, because then the judge will say, well, I have to consider this because I have this man on my stand as a witness, and I have to evaluate if he's a credible witness or not. And if he's been lying and having shady business practices in his professional life, I have to consider that as to whether or not he is telling me the truth on the stand in this courtroom.
Excellent points. Excellent points. Thank you very much. I'm all the way satisfied with that answer.
Wonderful. Anything else?
Yes. So Brother Polight, he debates for a living, as it were. So he's well versed and trained in defending himself. So Brother Polight taking the stand would actually tie into his ego, and many of us that know him personally would actually know that he more than likely would take the stand. However, my question pertains now to the young victim alleged in question. Does her taking the stand strengthen her case versus her not taking the stand weakening her case?
So whether or not her taking the stand would strengthen or weaken her case depends on her credibility. Because as we just discussed, witness credibility is always relevant. So if in fact, and we're about to have a conversation that I may say things that you may not, and not you, Zion Lexx, but viewers, right? That you as a viewer, you may not like, but I am telling you how the process works, okay? So if she is a girl who appears to be trustworthy, meaning she dresses a certain way, she presents herself a certain way, she speaks a certain way, she hasn't gotten into any trouble with the law, she tends to do well in school, right? These types of things. These are the kinds of things that the prosecution will look at and say, I have a solid witness. She dresses age appropriate. She speaks age appropriate. She, appears to be someone that would garner sympathy and garner you to think I can trust this girl. So the prosecutor is going to evaluate whether or not she would come off as a good witness, i.e., does she appear to be trustworthy? And then, of course, ultimately, she has to decide if she's comfortable testifying. If she is a strong witness and she testifies, there is nothing more sympathetic and more convincing than a child, a competent, trustworthy child witness, because juries understand, just like a judge understands, how much courage it takes to be on that stand. Imagine as an adult how nervous you would be to testify. And now imagine if you were a child testifying. So juries and judges, they see that, they recognize that. And so when they see a child on the stand, they think, wow, this took a tremendous amount of courage. So if you add to that she appears well and she comes across well, that could definitely make her case stronger.
Okay, let me ask you one more question. Would you agree that it's not in the best interest of the defense to badger her while on stand, to really, shake things up by putting, let's say, the pressure on her because of the delicacy of the case and the idea of the jury more than likely being sensitive to the young girl? Would you agree that the defense has to approach this in a very tactful manner, because the subject matter obviously is very delicate and the jury may not take a liking to that?
I would agree. And I'm sure that his defense team is aware of that. These cases always have to be approached in a very, very sensitive manner. And it has to be done in a way in which the defense attorneys are really talking about the evidence, and not attacking the victim. Because
Right.
attacking a minor victim is a terrible idea.
Mhm.
So I'm almost certain that that is not their defense tactic. It will probably be just to stick to the evidence doesn't show, the evidence is not solid, the DNA is shaky. It should probably be somewhere along those lines, and probably not trying to attack a minor, because that's a terrible idea.
Okay. Okay. Now, being that there is already a trail on YouTube of various videos where Polight is almost implicated or incriminated by people that he knows, inferring that Polight may have done this before with other people, how much consideration do you think a credible prosecutor will actually take that into consideration as useful info and work on it to the extent that there might be a YouTube video out there that might be extremely valuable in this case?
So here's what I will say to that. There are, to my knowledge, videos out there in which people affiliated with Michael Nowak allege that he has had inappropriate contact with minors in the past. This is not me saying that. This is not even Zion Lexx saying that.
That's right.
This is people that are affiliated with him have said that. Now, any prosecutor who wants, as I said before, a strong case is going to try to bring those allegations into this case. They have two ways they can do that. They can try to bring the actual video into court, which they have to overcome some hearsay issues, right? But perhaps they can find a hearsay exception. We don't have the time to get into all the hearsay exceptions today. There are so many of them. But know that there are many hearsay exceptions. So just because something is hearsay does not mean that it may never see the light of day in court, right? So they may try to bring in the actual video. Polight's defense attorney should say hearsay, objection to that evidence. And then the prosecution should provide some sort of argument that is either an exception or an explanation that would convince a judge to allow it in, right? That's one way.
Right.
The second way is they could get the actual person in the video. Hey, such and such. This is ADA or ASA from such and such Florida. I see you made a video regarding my defendant and his past conduct, and you're alleging that he's done in the past exactly what he did in this case. Would you like to speak to me, or should I subpoena you? You
All
let
right.
me.
And how strong, just for the layman, myself included, how strong is the power of the subpoena out of state? For someone in this case.
Subpoena power is subpoena power. It is the same all over the country. Now, of course, it's more likely that you're facing higher penalties if you try to ignore a federally issued subpoena, but
Right.
a subpoena is a subpoena, regardless.
Okay. So there aren't different levels of subpoena at all.
No, there's just different levels of consequences. It's
Okay.
just more likely that a federal entity could really go after you if you ignore them. That's what it is.
Okay.
Everyone
Okay.
has, as far as government entities are concerned, they all have the power to try to go after you in some way if you ignore their subpoena. You're just more likely to catch heat ignoring a federal subpoena than a state or a district subpoena.
What penalties, if any at all, are associated with failure to answer a subpoena?
It could be obstruction of justice. So if you're unfamiliar with that charge, obstruction of justice is when the government alleges that a certain person is preventing prosecution or preventing the development of a case because they either refuse to appear, or they refuse to give evidence, or they refuse to testify. So obstruction of justice is probably one of the main charges. And the judge could even find the person in contempt of court, because remember, the judge is also a part of this entire process and is signing off on and agreeing to these subpoenas that this person is allegedly just choosing to ignore.
Absolutely. Absolutely. Okay. 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 Having mentioned these videos on YouTube, so I initially reached out to let you know that I had actually uh, participated in a video debate with Brother Polight 11 months ago, in September of 2020, at, I believe, what was his Beverly Hills penthouse. And during this debate, um, the topic was centered around rape. And although Brother Polight did not at any time in the video definitively say that rape is okay, you do see him, however, arguing in favor of the idea that rape is not okay in the Bible being wrong. So my question to you is, how likely, if at all, can a video like that be used without a definitive statement? Would the prosecution take the time to play the entire 30 minutes and have the entire courtroom sitting, listening, and discerning it? Or would we need the key parts, if any at all, where he makes a definitive statement? In this case, he doesn't. And so because he doesn't make a definitive statement, it really has no value. What do you say to that?
So before I answer the question, I want to give a big hello to Information Man Show. If you're unfamiliar with him, I can't believe that. He's awesome. You should check out his YouTube. He covers a range of topics and does so eloquently. And I also want to give a big shout out to K Business Podcast, another great channel you should check out. He covers a lot of good business topics and gives great entrepreneurship advice. And of course, hello to Let Me See Your Transcript. Check her out as well. She also has some awesome content. Alrighty, so now to answer the question at hand. So some of these videos, which I have been sent them and I've reviewed some of them, do not have definitive statements in them. That is true. However, it depends on the diligence of the prosecutor as to whether or not, because as I said, it's an adversarial system. So you can always make the argument and let the judge decide. So a very diligent prosecutor is going to pull all of these videos, any video in which Michael Nowak even says the R word. They're going to pull it and they're going to take it into court and say, Your Honor, we're arguing that it should be admitted. We're arguing that here are our hearsay exceptions. Maybe it's an admission on the defendant's part. Maybe it shows his mindset in regards to this type of assault. Maybe it shows past conduct, this, and that. They have tons of arguments they can make. But a diligent prosecutor will trot out every possible video, argue for all of them, hoping that they maybe get at least 2 or 3 of them admitted.
Okay.
Now, a prosecutor who's maybe not as diligent or maybe not as tech savvy, you never know, may decide, you know what, I don't need any of that. I'm going to stick to my case. I'm going to just argue my case and call it a day. But I will tell you that from what I have seen, Michael Nowak's presence online is a treasure trove for prosecutors. I cannot imagine a prosecutor who would not see his online presence and go, oh, like, oh my goodness, jackpot, right? I cannot imagine a prosecutor that would not go through his online presence and try to use that.
Makes sense. All right. Okay.
So listen, we are at 7:47 here, and usually I'm on for about an hour. So unless you have any burning questions left, we could hop into the chat and take some questions from the chat.
Yes, let's do that.
All righty. Nappy Yankee, another channel you should check out and subscribe to, right? And take his advice. Like the video, share the video, and subscribe if you are not subscribed. And per usual, big hello to all of my OGs and also a big hello to the newbies. So we're now taking questions from the chat. This is the time. Drop your questions in the chat. Hello to Pocket Watching with JT, yet another talented content creator here on YouTube. He does amazing financial breakdowns. He's an actual accountant, and he's so graciously acquiesced to me tweaking his tagline and using a real lawyer reacts, right? He didn't give me a hard time about it. So he's also a great guy. All right, I see a question. So Veronica York George wants to know, Attorney Pearson, would you represent Nowak if he reached out to you? Now, I have been asked this kind of question before, and I always tell people I am a student of Johnny Cochran. May he rest in peace. That man was one of the greatest to ever practice law. And one of the first things he said to young attorneys is, you do not answer that kind of question. You do not answer who you would or wouldn't represent, and you never predict the outcome of a case. Okay, so unfortunately, that is a question that I'm not going to provide an answer to. All right, JW National says, can they prosecute his wives? What about his current minor girlfriend? All right, so first question, can they prosecute his wives if they can prove that his wives were aware of and involved in his inappropriate conduct with this minor? Then hypothetically, they could prosecute his wives. Second part of the question, what about his current minor girlfriend? I don't know if you mean the mother of this minor or if you mean that he actually has a girlfriend who's a minor. I'm not sure there. But if you're referring to the minor's mother, again, they would have to prove that she was aware of what was happening and that she allowed it to happen, right? Not that she found out after the fact, because after the fact, we know that she was a part of it being reported. Anything on that, Zion, before I move on to the next question?
No, none at all.
Just checking, because you looked like, the wheels were spinning. So I thought, does he have a question?
I'm still cooking something up.
Okay, all righty. Listen, we'll jump in whenever. All right, so let's see. Oh, Chief X is here. Wait a minute. Hello to Chief X. Yet another awesome content creator here on YouTube. Check him out. All right. Okay, let's see. So Bars and Chains says, do you think we could get fair jury trial with all the videos online talking about it? So I like this question for a number of reasons. I'm going to start with the first reason that I like this question. The question of, do you think we could get? So Bars and Chains, unless you are Michael Nowak, unless you are, which I don't think you are not the person that would be on trial. And I pulled out that word because I want to challenge us as, just as people here in this space of YouTube, and especially on my channel, to separate yourselves from people that we discuss. We are discussing the law. We're having a professional, legal, unbiased conversation. But learn to separate yourself from a lot of these quote unquote public figures. So unless you are Michael Nowak, Bars and Chains, you're not the one on trial. Okay. Now, do I think that he could get a fair jury trial? I do, because although there is a sector of people online having this buzzing conversation, there are still many people out there who have no idea who he is or what we're discussing. Okay. All righty. I see a question from Octavius Prime that I'll address for a minute. Octavius Prime would like to know, how much prison time is he facing if he goes to trial? Octavius Prime, please see the state of Florida versus Brother Polight, part 1. Therein, you will find the answer to your question as well as a full breakdown of his charges. All right, Sam Sims. I believe Polight will say his DNA was on the girl as a result of his interactions with the mother. Would that defense stand up in court? What will prosecutors argue in response? Wonderful questions. So the first question is, would it stand up in court if hypothetically, allegedly, Michael Nowak tries to argue that his DNA was found on this girl as a result of interactions with the mother? Well, quite frankly, that depends on how he can substantiate that. right? So if in fact he decides to provide that sort of defense, then perhaps his defense attorney would provide some sort of forensic scientist, right? That could testify to how DNA can remain on clothing over a length of a period of time, right? Because the argument would have to be made that perhaps the girl was wearing her mother's clothing or there was some sort of transfer. And to make that sort of elevated scientific argument, they would need an expert. So an expert witness who supported that argument, they could make it. And if their expert was deemed to be credible enough, maybe it would hold up in court. I will say this, though. If you were not familiar with Nicki Minaj's brother, I believe his name is Jelani Mirage, he faced some similar kind of, accusations. And one of his defenses was DNA transfer, that somehow his DNA ended up in certain places on the minor by way of it being transferred from somewhere else. So from the mother or the mother's clothing or etc. And that defense did not stand up. He was convicted. Okay, so now the second part is, what will prosecutors argue in response? So of course, if in fact this argument is made, hypothetically, prosecutors would also have their own scientists who would rebut that testimony. Okay, I'm back in the chat. Interesting. Okay, so JW National Web Design says, what about his current wife being 16 when they got married? So I was sent a clip of an interview with Michael Nowak and two women who he identifies as his wives. One of the women alleged that she was 16 when she met him. Here is the thing. She does not allege that she was 16. Well, actually, she doesn't say she was 16 when she met him. I don't think that's what she says. But I think she says she was 16 when she started speaking to him and the other wife, right? I believe so. But here's the bottom line. She does not say that he began to touch her in any way, be physical with her in any way, or even speak to her romantically in any sort of way when she was still 16, right? At least not from what I saw. So that would not be relevant unless somehow they could find evidence of that, okay? Oh boy, I see a question that I'm going to answer, although the way that it's phrased isn't my favorite phrasing, but okay.
Yeah.
So the question is, can Mr. Nowak sue YouTube content creators? Okay. So here it is, people. When you position yourself to be a public figure, you forfeit a certain amount of privacy. The law views public figures as people who people can discuss, people can talk about within reason. So Michael Nowak fashions himself to be a sort of public figure, right? I mean, yeah, he does. So now he already has the reduced privacy protection because he's a pseudo public figure, right? Now you add the fact that people are not discussing allegations from the back of the woods somewhere. People are discussing allegations that are in a police report as provided by the Miami-Dade clerk's office. That is public record. So what cause of action would Michael Nowak have? He doesn't have defamation because false statements are not being made, right? People are reading police reports. People are reading charges from the clerk's office. So there's no false statements. He also doesn't have harassment because, again, people are reviewing public records and he is a pseudo public figure. He doesn't have intentional infliction of emotional distress because, again, pseudo public figure, public records. So I do not see what the cause of action would be. Of course, perhaps he could find some lawyer somewhere who would say, yeah, we can do it. But would it be successful? I don't think so. Okay. Sexy Star says, will the prosecutor get video from the hotel he went to with the victim and use that as evidence? And will the jury look at the health condition of the victim after she left the hotel? So yes and yes. If possible, the prosecutors will want to get video surveillance from that hotel to show the minor allegedly entering with Michael Nowak, leaving with Michael Nowak, right? And the jury will also want to see, if available, any medical records that substantiate that something occurred to her while she was there. Okay. All righty. Let's see. I see some people here who want to be in timeout. I don't get it. You come here, I would think you want to hang out, have a legal convo, skip through the meadow with me and Zion Lex, but no. You want to come here starting trouble and finding yourself in timeout. I don't get it. Bars and Change says, could his bond get revoked at the next court hearing? Yes, it could. Bail/bond can always be revisited. So it is possible that at the next hearing, it's revisited and a different decision is made. All right, question. Oh, K Business wants to be a moderator. Absolutely. Let's make that happen. K Business, you are now a mod. Okay, I see another good question here. Oh, what happened to the question? Oh, here we go. Sam Sims says, what does a good lawyer look like for this case? Meaning, for anyone facing these charges, what qualities or specialties should they look for in a lawyer? I love this question. Let's have a conversation about what you should look for in any lawyer, right? So first, if you are going to hire an attorney, you go to the State Bar website. We've been having this combo a lot, but let's do it again. You go to the State Bar website for your state and you go to attorney lookup. You first want to make sure that that attorney actually has an active license, right? So you want to make sure they are a licensed attorney. Don't take their word for it. The attorney lookup will also tell you if they've had some, major disciplinary action on their license. So first things first, you're going to hire an attorney, go to the State Bar attorney lookup and make sure they are a licensed attorney. Now, qualities that you want in a lawyer. Again, you know that we like to have a level of authenticity here, right? I like to be authentic. So I'm about to tell you some things that I think most lawyers wouldn't tell you, but this is the truth. You want a lawyer who is likable. If you meet them and you don't like them, forget it. Because if you don't like them, judges don't like them. If you don't like them, juries won't like them. And likability is very important. If someone is not liked, then people usually just start tuning them out. So if you get an attorney who's not likable, the minute he or she starts speaking, no one is listening. And now you're in trouble. Okay. So likability, are they a likable person? Again, look and make sure they have a valid license, right? And then ask them about their experience in your area. So if you are hiring an attorney, for example, facing these kinds of charges, ask them, have you defended people before with my exact charges? How did that turn out? Can we discuss what your tactics were in that case? So those are the main things. Valid license, experience in your area, likability, underscore, highlight, likability, bold letters, likability. Likability is everything. If you don't like them, no one else will, and you're in trouble. Okay.
I wanted to give you an exclusive.
Yes, go ahead.
All right. So, according to sources who are close to the alleged victim's mom, apparently there may be allegedly a video surveillance tape from outside of the hotel, which may in fact be showing Brother Polight struggling with the victim's mom and preventing her from retrieving her child, according to said sources. My question for you is, if such a video exists, how much of a bearing does that have in the case?
If there is video surveillance which shows Michael Nowak struggling with the minor's mother and trying to prevent the mother from retrieving the minor, that insinuates quite a few things. First, that insinuates that the minor was in some sort of condition that Michael Nowak did not want the mother to see her in. Again, going back to the allegation that he perhaps gave her alcohol or he allegedly drugged her, right? That allegation that he made her incapacitated in some way, that feeds into that. because it's valid that if she was incapacitated, allegedly, he wouldn't want her mother to see her that way. Because the minute the mother sees her that way, she would think, what is wrong with my child? What have you done to my child? So that's the first thing. The second thing is it also feeds into the allegations that he did something inappropriate with her. Because again, if he did something inappropriate as alleged, he would not want the mother to see the child right away, because perhaps the child is still traumatized. Maybe she's still in a state where she's, upset, and he does not want the mother to see the minor like that. So if that surveillance exists, it does support the current allegations.
Okay, thank you very much.
You're welcome. You're welcome. And Rose says, this lady is smart. I wish she was my friend. Rose, we are friends. Welcome to the club. All righty. Black Anonymous has a question. Another content creator here. All right. Black Anonymous says, oh, is that a question? Yeah. I'm thinking kidnapping could have been a charge because he took the child away without permission. What do you think at Empowered Aspire TV? So I would think that if the prosecution felt they had the evidence to prove kidnapping, they would have charged it. And we know that he was not charged with kidnapping. So we can insinuate that possibly, hypothetically, they do not have the evidence to prove that Michael Nowak was with this minor without permission. Because if they did, they probably would have charged kidnapping. Okay? Just my thoughts. I do not see any other questions on. Oh, wait. Crime Spotter says, why is it Polight not stating he's guilty? Any legal reasons? Crime Spotter, do you mean not stating that he's not guilty?
Yeah, I think that's probably what they mean.
We're going to go with that. We're going to go with why isn't Polight stating that he's not guilty? So I'm going to give you the lawyer answer and then the authentic answer, right? The real talk answer. So the lawyer answer is perhaps he was told or advised by his attorneys not to address his guilt or innocence. Perhaps his attorney said to him, do not address your guilt or innocence online. And maybe that's why. Now, the person answer, right? The real talk answer is perhaps he feels that he would not be able to say that. Perhaps that's why he hasn't said it. Maybe. Allegedly. All right. Let's see. Questions. Okay, so someone wants to know. This is a good question. Daryl Jackson wants to know, can the charges be amended? Yes. Yes, they can be amended. Very often, superseding indictments and things like that are filed, whereas charges are amended. So charging documents are amended all the time. It can happen. Yes, the charges can be amended. Okay. Major Moves wants to know what will happen at the first appearance. Well, Major Moves, there are a couple of things that could happen, right? So as we've discussed, bail could be revisited, right? And also it could be discussed in regards to what, preliminarily at least, what evidence the prosecution has and any type of motion practice that may need to take place before a potential trial. Okay. All right, let's see. I'm scrolling through. Coco Brownie says he's lawyered up. Yes, he is. His attorney is a man named David Taurus. JW National says, what about the state taking away his newborn child and relocating the mother due to his predatory ways? Good question. So I am actually in possession of a document, a complaint that was filed by Michael Nowak, in which he alleged he was suing ACS, the state of New York, the city of New York, a caseworker, and the mother of his daughter. This is back in 2014, I believe. I decided not to trot this stuff out. I don't remember why I decided not to. I don't know. For some reason, I decided, I'll leave it alone. You know why? Because Chief X and a few other people already addressed it, and I said it's beaten. Chief X discussed it, and I think, oh my goodness, I hope I do not butcher his channel name, Moorish TV.
Yes. Shout out to Moorish TV. Mm-hmm.
There you go. He discussed it as well. So I thought, it's been covered. They don't need me to cover it as well. But there is a complaint in which Michael Nowak alleges that ACS pretty much refuses to allow him to be in his child's life. I don't know for sure that the mother was relocated based on ACS's actions. I'm not sure about that. But I will say this. That case in particular, if there was an ACS case as is being alleged, right? So I did not see ACS documentation. So I'm saying if there was an ACS case as is being alleged, that could be something that's relevant in this case. Because remember, one of the charges in this case, other than the intimate charges, is what? Contributing to the delinquency of a minor. So this ACS case in which ACS said, you know, we don't think that you're a good look for a newborn child, that could be made relevant in this case. Perhaps the prosecutors in this case may go to the state of New York and contact ACS and say, can you send us that documentation? We'd like to use it. So yes, that conduct, because it is conduct that involves a minor and it is allegations of endangering a minor in some way, not being fit to be around a minor. And that could most certainly be found to be relevant in this case. Daryl Jackson, by the way, we're at 8:09. So I will ask our guest if he has any other questions. And then if he'd like to go, I'll let him go. We're not going to hold him hostage, but I'll stick around for some more questions. All right. Daryl Jackson says, is there anything in his past that can demonstrate a consistent pattern of behavior or a propensity for said charges? Okay. So let's stick to pattern, because propensity evidence in general is not allowed, right? So it's not propensity, it's a pattern. Let's stick to pattern. So you have allegations from people who once knew him in regards to a young lady that he allegedly was inappropriate with. Then you have ACS allegedly saying that he wasn't fit to be around his own child. Then you have videos in which he tends to insinuate that contact with a minor is okay. All of these things, when you put them together, the argument could be made that you're looking at a pattern. Question from, oh, wait, it disappeared. All right, question from Venom. Can he be charged for the threats that he is making online towards people that may have information about his present crimes or past crimes that may go with these crimes? Well, any threats that he's making online could definitely be something that people could file police reports. People could say they're being cyber stalked, say they're being cyber harassed if he's making threats online. But as far as this case, probably not. Okay, probably not.
Could I ask you
Yes.
if in fact the case actually goes to trial, right? And matter of fact, let me preface it with this statement. Does his court date on September 15th automatically indicate that this is going to trial? Could you first differentiate that for us? Someone having a court date and someone having a trial.
So if you look at the Miami-Dade clerk's office and you look at what they say the status of the case is, they state that the next court date is a pre-hearing, right? It's a preliminary hearing. It is not the trial. And there are still many things that could happen before trial, right? We still have the possibility that the charges are amended, as we discussed. We still have the possibility that bail conditions are amended, as we discussed. And we also still have the possibility that some sort of deal is made and Michael Nowak decides to, plead guilty. We also have the possibility that the prosecution decides, you know what, we're actually not going forward with the case. That is still a possibility.
Okay, and which leads to my follow-up question. So in the case that the case actually goes to trial, and let's say damaging evidence begins to accrue against Brother Polight's narrative, how much will his YouTube bravado videos hurt him at that point if evidence is being surmounted and built and stacked against his favor, and then the prosecution pulls up all of the videos of him showing bravado and this is nothing and making light of the case? What do you say to that?
So what I say to that is that his attorneys should advise him to get off of social media. I've said this several times that his attorney should, and maybe they are, and he's just not listening. Because I can say as an attorney, sometimes clients do not listen. But they should be advising him to get off of social media. I watched your interview on Tasha K, on Tasha K's channel, and I see when Tasha mentioned, I haven't seen the video myself, I have to say that, but I see when Tasha mentioned that she viewed a video of Michael Nowak right after these charges became public, pretty much talking about women that he's been with in an intimate way, bragging about having been with a lot of women. That is not a good look, especially when you're facing these type, this type of allegations. So he should get off social media. Truth be told, he should just get off social media, because all of these things, as I said, a diligent, zealous prosecutor is going to argue for all of these things in hopes that the judge will say, I'll allow it. And then all of this YouTube stuff gets brought into court.
Thank you so much.
You're welcome. You're welcome. Do you have any other questions? Would you like to go? Like I said, we're not going to hold you hostage. I'm going to stick around for.
I'm gonna go. I'm gonna go, and I'm allow you to close out. But the first thing I want to do is say it was an honor to be on your show. Like I said, I watched the first video, and from watching it, the first thing I said is we got to have a conversation publicly as well. So I'm glad that we were able to accomplish that. Much success to you in the future, and I hope to maybe have another dialogue sometime in the near future. Have a blessed evening. All right.
Thank you. You're welcome back anytime. Have a good one and recover well.
Thank you so much.
All righty. Bye-bye.
All right. Take care.
Everyone say goodbye to our guest. Mr. Zion Lexx is leaving the building. All right. All righty. So I see we got a good conversation going on in the chats. I'm going to shout out some of my OGs because I can't get around to every single person today. Tagar Kelly. Hello, darling. Sir Anthony. Hello. How are you? Let's see. I'm scrolling through. Like I said, just shouting out a few people that I know I've seen around before. Lisa Johnson, how are you? Gorgeous profile pic, by the way. Okay, honey. Slay. Let's see. All righty. So I think that's it for the OGs, right? So if you're new here, if you're a newbie, welcome, welcome, welcome. I'm going to stick around for a little longer and take a few more questions. A. Womack has a question. The fact that Polight was given bail and allowed to travel back to California, does this mean that the prosecution doesn't have much of a case? A. Womack, you should go back to the beginning of the stream. We had an entire conversation about bail. I actually put up a document where I explained what bail is and why it is that he could have been granted bail. Okay, so take a little trip back to the beginning of the stream and check that out. And Amara Sharice, hello. Hello, yes, catch it on the replay. All righty. So any other questions? I don't really see any. Oh, wait, Venom. Can the people in the HOK that are making intimidating comments on the case be held accountable? Yes. Anyone that is threatening people online, threatening any type of physical violence or something like that, that can be deemed cyber harassment or cyber bullying, and there are civil causes of action for that. Okay, so I would not advise anyone to be online bullying other people. You should just allow people to have their opinion, agree to disagree. Que sera, sera. All righty. Oh, Rose made a good point. If you're in the building, hit the thumbs up button. Why? Because you're here, we're having a good time, and you're getting your legal questions answered. I mean, come on now. Hit the thumbs up if you're here. Garnett Crawford has a question. Oh my goodness, here it is. Almost lost it. Garnett Crawford, would the prosecution look at Polight's finances? It depends, right? If for some reason they thought there was something in his finances that could be relevant to their case, then yes. Nene Baby would like to know what happens if his attorney asks to be removed. Well, if the attorney petitions the court to withdraw as counsel, more than likely the court will approve. His attorney can withdraw, and then he's free to retain new counsel. All righty. All right, Pop Off Gaming says, can someone please answer this question for me? If the police have 100% DNA evidence from this person that is being accused, Will the judge give that person bail? Pop Off Gaming, please go back to the beginning. I'm sorry that I took that deep breath on you. Transparent moment. But if you're just joining us and you have a question about bail, go back to the beginning of the stream, please and thanks. Let us see. I'm just scrolling through, plucking out questions as I go along. Health Light says, if he makes contact with the minor, will it damage the case? It could. It could, depending on the contact that is being made, especially if it's threatening contact. Damage the case, actually. Let me change that answer. Depending on the contact being made, if for some reason it is contact that suggests that they are on amicable terms, maybe that could damage the case, because that could give the impression of them being amicable and there not actually being any contention about what occurred, which suggests that maybe it did not actually happen. Possibly, hypothetically. All right, I don't see any other questions that we can really review. I see Sun, Moon, and Stars. You have a question that I already answered, so take it back a bit, right? And you'll see the answer to that. Jessica Holmes, I see you also have a question that I'll put up. Jessica Holmes says, if the victim does not wish to testify on the stand, can her forensic interview be used, assuming that one was performed? Yes. Jessica, go back to the beginning of the stream. We talked about evidence-based prosecution. So listen, if you're catching this on the replay, hello, how are you? Welcome. At the beginning of this stream, we discussed bail. We discussed why it is that Michael Nowak could have been granted bail via what the legal requirements for bail are. So if you have a question about bail, go back to that. We also discussed evidence-based prosecution, i.e. cases in which the prosecution goes forward with a case without having a cooperative victim. So when the victim decides not to be a part of the case, not to go forward, but the government goes forward anyway, that is also at the beginning of the stream. All right. Crime Spotter would like to know, would he have to register as an offender even if there's a plea? Well, Crime Spotter, that depends on the plea. If the plea is some type of, as we say on this channel, intimate offense, then yes, he would have to register. But if the plea is not that type of offense, then he would not have to register. All right. Alrighty, so I am going to go ahead and hop on out now. If you have a question that for some reason I did not get to, put it in the comments below. You know, I'm very active in the comments. If there's anything that you all could say about me, you got to give me that. You got to give me that. I'm in those comments, right? You're asking questions, I'm answering. You're asking questions, I'm answering. I'm liking, I'm saying hello, what's up, how are you? So if there's a question that you have that I did not get to, drop it in the comments below. And if you're watching this on the replay and you have a question, you are more than welcome to put it in the comments as well. So this has been another installment of Empowered Esquire TV, where we, new tagline, empower you with legal knowledge. I hope you feel empowered by the information I shared today, because you are powerful and amazing in your own right. It's been a good one. I'll see you later.